I was listening recently to your argument in United States versus Kakinda, because that's the post office case.
Right.
And the first 40 seconds, you nailed it. You seemed to have that first 40 seconds down perfectly. It seemed to have been memorized, but it was delivered very naturally. Do you believe in memorizing just the opening part of the oral argument, the entire oral argument, and then being flexible enough to alter what you're going to say a little bit?
It kind of follows up on my previous answer. I will tell you I don't believe in memorizing what you're going to say. But when you've practiced it as many times as you need to do, in effect you are memorizing it. You're internalizing it. You're not sitting down and memorizing, here's a block, right, this is my answer to this question. But if you practice giving the answer to that question 12, 15, 20 times, your mind has got it there, and you may not give it precisely the way you would as if you'd memorized it, as if you'd memorized the Midnight Ride of Paul Revere in 4th grade or whatever. But your mind is going to click into that and be able to give it without too much thought about exactly how to formulate it. Now, the opening in the Supreme Court, you're only guaranteed usually about a minute or so, a minute and a half before a justice is going to jump in. So I always thought it was very important to work very hard on those first few sentences. You want to convey exactly what you think the case turns on and why you should win, not just the issue in this case is blah, blah, blah. They already know that until you're not doing anything. You're not moving the ball if you're just telling them what the issue is. You've got to frame it in a way that makes your main argument. So they understand right from the beginning the focus is on this particular statutory phrase. The focus is on this particular precedent. The focus is on this particular consequence that will happen if you don't rule in my favor. And get that right there at the beginning, because it's often a way to guide the questioning. You want to do it in a provocative way. Bring out the question that you want to be asked at that point so that you can respond to it. And then right away you're out of any type of memorized presentation. You're responding to a question, but it's a question that you have elicited or planted by the way you opened the case, and it's obviously one you want to be able, not the one you're not going to be able to answer, but the one you are going to be able to answer to get the case off to a good start.
This may not be perfectly analogous to an oral argument, but I remember watching your opening statement to the United States Senate before the Judiciary Committee, and you never looked at a note. You were looking at the committee members, and I imagine a lot of lawyers consider it to be the most impressive public utterance they've ever heard. Certainly I think of it that way. And that must have been memorized, but it was delivered very naturally. Or did you just rehearse it a lot?
Obviously I thought about what I was going to say, but that first day the senators gave their opening statements first, so you couldn't really memorize it. I didn't know what the first 3 hours were going to be like. If they were all going to be focusing on one aspect or another aspect, or were going to bring up certain things that demanded a response, it would have been very wooden and artificial to give a pre-rehearsed opening after, as if you weren't there listening to what they had to say. So I thought about it. I knew there were some points I wanted to make, but at the same time, you wanted to be genuine and respond to what they had to say and lay out what was, your strongest case. So it couldn't, a memorized statement that was just given by rote wouldn't have been very successful. So obviously I knew what I wanted to say and the points I wanted to make, but it also had to take in what had gone on before.
So a lot of that was extemporaneous.
I thought about what I wanted to say, but I didn't have a script. I remember them asking me before. They said, on our procedures, we need your written statement 4 days before. And I said, well, I don't know what it's going to be, because I'm going to be listening to what you say, and I have to react to that. So to that extent, it was extemporaneous.
Can bad writing lose a strong case?
Sure can, because they may not see your strong case. It's not like judges know what the answer is, and they're going to, we've got to find it out. And so when you say, can bad writing lose a strong case? If it's bad writing, we may not see that you've got a strong case. It's not that oh, this is poorly written, so you're going to lose. It's that it's poorly written that we don't see how strong the precedents in your favor really are, because you haven't conveyed them in a succinct way, or we don't see exactly how the statutory language works together to support you because you haven't adequately explained that. Or even simple things, you haven't put it in there. You're telling us about why it should be read this way when we haven't even seen it yet. I've seen briefs like that. The statute should be read to this. Well, for goodness sakes, what's it say? Let's start with that. So sure, we're hostage to the language as much as anyone else is. And if Congress doesn't do a good job in its use of language, it makes it hard for us to figure out what they have in mind. If judges who've gone before haven't done a good job in their opinions in explaining how they're reasoning to reach a particular result, that's going to handicap us. And if the lawyers don't write clearly enough to convey the arguments, it's going to be very difficult for us to get the case right.
And presumably good writing can win not a complete loser, but a questionable case.
I have been very fortunate as a lawyer to work with some great associates and fellow partners. And I have found that I really have to be on guard when I'm dealing with a good writer, because you pick up the draft of a brief, say, or a draft of a memo, and you read it through, and if the writing is good, it's got a certain thing, you put it down, and it sounds right. And sometimes when you go back, it's not right. So it's certainly the case that good writing can cover up some weaknesses, that's for sure.
How does an advocate at oral argument learn to turn a judge's question into a transition to the advocate's next point? Isn't that a great challenge?
It is. Now, I have a particular practice approach that is addressed to just that point. I don't care how complicated your case is, it usually reduces to at most 4 or 5 major points. Here's the key precedent, here's the key language, here's the key regulation, here's the key consequences that you have 4 or 5 points. It's called A, B, C, D, and E. And when I'm practicing giving the argument, I go through it, and then I'll just shuffle those cards, A, B, C, D, and E, without knowing what they are, and then I'll start again, and I'll look down. Okay, my first point is going to be C, and then from point C I'm going to move to point E, and then from point E to point A. And you develop practice on those transitions, so that if you get a particular, because that's how it always works at any appellate court, you can't guarantee the first question you're going to get is going to be on your first point. It may be on your third point. And everyone has seen this, and it's very awkward for somebody to say, after they answer that third point, and now I'd like to go back to, the point I was making. Well, okay, it's not very smooth, and you kind of lose a little bit of traction. If you've practiced giving that argument, third point and then to the first point or then to whatever, you can make those transitions, and it's much smoother. And again, it conveys a greater degree of confidence on your part in your presentation, that you're not pausing and saying, I'll go back to something else. It prevents the argument from seeming disruptive, and it makes it look fluid no matter what questions you get or in what order the points come out.
I must have read hundreds of articles on oral advocacy. I've never seen that tip before. I think it's brilliant.
It's a great way to practice, because everybody will practice, okay, points 1, 2, 3, and 4, 1, 2, 3, and 4, and they get so set in that mode. And the first thing that happens, of course, is some judge like myself asks you about point 4 when you get up there. And you think, the worst thing, sometimes you speak, well, I'll get to that later, which you never want to say. Or, in effect, you kind of disaggregate the argument, saying, okay, I'm going to answer your question on point 4, and then I'm going to go back to point 1, and we're going to go through it all again. And you develop a much more comfortable facility with the whole argument if you've practiced it, point 4, then point 2, then point 3, and then point 1, because those may be the order in which you get the questions.
Do you have any other favorite practice tips in preparing for oral argument?
It's a I don't know if it counts as a tip or not, but it's something I do both with respect to oral argument and with respect to the brief. And that is, before the brief is due or filed, a little bit of time, and comfortably before the argument, sit down with either a layperson or a colleague in your firm or office that has had nothing to do with the case. It doesn't even, a non-litigator is what I would look for. And just drop the brief on them and say, look, can you spend a half hour, just read this brief and tell me what you think? And he'll look at it and says, well, it's an ERISA preemption case. I don't know anything about that. And he said, just read it. And if that person can't come back to you after reading through it once and say, answer two questions, what is this case about and why should I win, you need to go back and start over. Because, yes, your audience is going to be a judge or whatever, and someone who knows more about it. But at the same time, they're going to be dealing with a lot of different stuff. And if an intelligent layperson or an intelligent lawyer who's not a litigator and not in that area sits down and says, it's about ERISA, I don't understand what's going on here, you haven't made it clear enough. It's not clear enough. And the same with an argument. Now, don't give the argument to a layperson, but you take 5 minutes and say, look, in 5 minutes, if you can't explain what's this case about and why should you win, you've got to go back and practice it again. You're too immersed in it. You're too much at the level of jargon, or you don't understand it. So you talk to, your parents or your sister or your brother who's not a lawyer. So many times you'll say, well, you've got a case. What's it about? And you think, it's antitrust state action. It's too complicated. I can't explain it. Then you're not ready to give the argument. Instead, you ought to be able to tell them in simple English that they don't have to be an expert exactly what it's about and why you should win. And if they don't leave that case and say, oh, I see why that's not fair. That doesn't make sense or whatever, you've got to do some more work.
But a lot of people insulate themselves from that sort of criticism, don't they?
Well, they do, and you see it in moot courts. You mentioned earlier, it's a great thing now. There are a lot of groups giving moot courts. So you have, you're pushing a case for an environmental group, and you look at the moot court, and it's all the people from the environmental groups, and they're all, no, you want the people from the other side of the ones who are going to ask the hostile questions, the ones that are going to, because the judge is certainly going to do that. The judge isn't interested in being singing to the choir or being a cheerleader. They're going to probe your position. So if you're going to do a moot court, get people who are not going to be naturally inclined toward your interest. Same thing if you're representing business interests. Don't get all the folks from the business groups there. Get people from the other side. You can do it at a
consumer advocate.
Yeah, or you can do it at a big law firm because here's somebody who's not going to agree with our position here. Let's put her or him on the case and the moot court, and we'll get some good questions, and you'll be prepared. And the same with my point earlier about just getting someone who's not involved in the area. Often people will get folks, this person's worked in this area for years. He'll know all the tough questions. Well, fine. The judge hasn't worked in it in years. And what I've seen many, many times are expert lawyers befuddled by the simple question. That you're at this abstract level of preparation and the question is kind of down here. You haven't thought about it. It's not a hard question, but it's one you haven't prepared because you haven't thought about, what somebody just getting into this area might think and how they'd have a problem. So you tend to give a bad answer. Or you tend to give an answer that doesn't help move your case along. You need, and you see it on our court with 9 judges. We have 9 different levels of sophistication in any particular case. One of the justices may have written 20 opinions in this area over the last 20 years and know it, from top to bottom. Another, maybe the first case of its type that the judge or justice has heard. And, you have to be prepared to answer at both of those levels.